SJC-12603, Ben Branch and others v. Commonwealth Employment Relations Board.
Mr. Cameron, good morning.
Mr. Chief Justice, Associate Justices, good morning. My name is Bruce Cameron, and I would like to first begin our discussion with exclusive representation and how the union uses it to circumvent the free speech rights of my clients. You see, the United States Supreme Court recently in Janus versus AFSCME held that employees, public employees who decide not to join the union cannot be required to support the union at all. Now, the issue in this case is not whether or not the union is willing to listen to my clients. Rather, the issue is the tariff. This amount that the Supreme Court said in Janus cannot be charged. Now, it's not just the U.S. Supreme Court. In 1982, this court in School Committee of Greenfield versus Greenfield Education Association held that employees could not be required to support the union's political and ideological expenses. The Supreme Court in 1977 in the Abood case said the same thing. And so what's happening here is that the union is coercing my clients by saying, we will not allow you a voice and a vote in your workplace conditions unless you pay our political and ideological expenses, unless you pay the tariff that union members pay. Now, in Janus, the court said that even less obvious forms of coercion are illegal. If you look at the very end of the Janus opinion, the Supreme Court talks about the procedure by which employees object. For decades, employees had been required to hold up their hand and say, I object to supporting the union's political and ideological.
Has any court post-Janus accepted this argument?
To my knowledge, no court post-Janus has heard this argument. There are a number of cases.
Trial courts, right?
Pardon me?
Trial courts have.
No, I don't believe even trial courts have heard this. What I believe you're referring to, Your Honor, is that there are a number of cases that have decided on whether or not exclusive representation is unconstitutional. I'm not challenging exclusive representation. If I win, not a word will change in Section 4, Section 5. Unions will still be exclusive bargaining representatives. What I'm challenging is the union using its authority granted by the government as the exclusive bargaining representative to force my clients to support its politics.
Can you be specific what you're asking for? Because I have trouble figuring out exactly what you want.
I would be delighted, Your Honor, to explain. When I talk about a voice and a vote in workplace conditions, I'm talking about this. I'm talking about attending union meetings where they discuss bargaining proposals. I'm talking about having a vote at union meetings on what the proposals of the union would be. I'm talking about voting on...
You're basically asking them to be members of the union without being members of the union?
Well, no, they would not be members of the union. I mean, union members engage in a contract with the union, and they can be punished for engaging in conduct and becoming a member of the union. They also would not be able to do things that I would say as, a further explanation of this answer.
Would you finish the specifics and then turn to Justice Cypher's question?
Yes,
okay. I'd just like to know exactly how, because having done this before, I'm just trying to figure out how this is going to work in the real world, okay?
They would be allowed to have a voice and a vote on bargaining proposals. They would have a voice and a vote on the negotiating process. That is, if they wanted to be members of the negotiating team, they could run for it. They might not win, but they could run for it. And so anything that had to do with what controls their workplace conditions.
So they would be, even though they would not pay union dues, they'd have all of the same rights to participate in union negotiations, be on union committees. I'm not oversimplifying, I'm just trying to understand what they would and wouldn't have.
Yeah, union committees that deal with collective bargaining, that is the contract. They wouldn't, for example, be able to run for president of the union. They wouldn't be involved in the administrative structure of the union, except
But could they be the lead negotiator in the negotiations?
Yes. I mean, obviously, there's a vote. So my clients, as non-members, might not win the majority of the vote of those who are voting on the negotiating committee. But at least they would have the opportunity
So
to
let me
run
just
and be heard.
clarify one other part.
Sure.
That you're not asking that they bargain separately? You're
No.
not- So they would, the exclusive representation scheme would still exist, but you would not be bargaining around it. You would be bargaining through the union? Is that what you're asking for?
Yes, because we're not trying to disturb the system any more than necessary to give my clients a voice and a vote. And that's why I say there's not another case like this, other than when you say cases, there are non-union cases, such as the Rutan case. But let me get to your question. I don't know if I adequately addressed that. You said, well, they'd be union members as a practical matter, and the answer is no. They would only have a voice and a vote in their workplace conditions. So they wouldn't be faced with this Hobson's choice between either their political autonomy or a voice and a vote in those things that most concern every employee: working conditions, pay, length of time.
So hypothetically, every member of the union could make that choice to not be a member of the union and then reconvene and effect the same bargaining? Could that happen?
Every employee could make that choice. Now, how that impacts the union is another question. After all, unions presumably get there by majority support. And if everybody decides not to be a member of the union, then they're not going to have a union, and they would be representing themselves. But we're not asking for that in this case, except to the extent that a union says, we are going to continue to try to coerce you to support our politics. We say that if that is the union's position, then the union can no longer be the exclusive bargaining representative. They have violated their rights, their obligations under Section 5, Chapter 150E, Section 5, and they violated their...
I misunderstood your answer to Justice Kafker's question, because I thought you told him you were not looking for a way that there would be no exclusive voice.
That's correct. I'm not...
But that could happen.
Well, it could happen. Now, is the union going to say, well, we're going to stand on our position that non-members have to make this choice? A union's not going to do that. But that is the logical result. If the union continues to insist on violating my constitutional rights, that is, my client's constitutional rights, then under the system, they would no longer be the exclusive bargaining representative. After all, this court has held in the Leahy case...
But I don't understand. So could they vote, I mean, could the union have a vote? Say we accept your premise that they would have some right. Could the union have a vote saying, no, if you don't pay the union, if you're not a member of the union, you're not going to be on the committee? Could they vote then? We give you this abstract right, and then they vote and say no?
Well, I would say that if you rule in my favor, hand down a decision that says this choice cannot be required, and union votes to still bar my clients from a voice and a vote unless they support the union's workplace conditions, then that union would not be the exclusive representative, that they would have violated their right.
Then you're asking then for if they do that, then you want to be able to vote, negotiate separately?
Well, the goal is not to negotiate separately, but I'm saying that they cannot put the non-members to this choice. And if they do, then there are logical consequences that follow. Just like anyone who's violating the First Amendment rights of someone else, there are logical consequences that follow. And in this case, this court has said that the duty of fair representation has a constitutional bottom. In the Leahy case, you held that if Section 5 did not exist, and there was no statutory obligation for the duty of fair representation, it would be implied by your Constitution. Your Constitution would require such a thing.
But we've never said the duty of fair representation extends into sort of minority representation in negotiations, or, right? We've always said the duty of fair representation has to do with grievances and equal respect for different members, right? Or not even members, but people in the bargaining unit.
I don't think so, Your Honor. If I might convince you.
We've said that duty of fair representation incorporates a duty to represent minority, to have minority views expressed on bargaining committees and things like that?
when you say "we,"
We, the
I'm
SJC.
talking about I was talking about the government, because if you actually look at the text of Chapter 150E, Section 5, it says that the union must represent all employees in the bargaining unit without regard to union membership. I'm saying.
But that's always been interpreted consistently with an exclusive representative, hasn't it?
The union is the exclusive representative, but the evil is using that authority to compel my clients to support the union's politics. Now, this is where the Rutan case comes in. Now, the United States Supreme Court in Rutan versus Republican Party, 497 U.S. 62, teaches that you cannot pressure employees to support partisan political activities. And in that case, the question was whether or not you could condition promotion and hire on affiliation or support of the Republican Party. The lower court in that case had said, well, this is a dismissal level problem, that if the employee is dismissed, then it's a problem. But the U.S. Supreme Court in Rutan, just like the U.S. Supreme Court in Janus, said less obvious forms of coercion are not permitted. And they said, let me quote this to you because I think it fits my argument perfectly. The First Amendment, ellipses, protects state employees not only from patronage dismissals, but also from even an act of retaliation as trivial as failing to hold a birthday party for a public employee, ellipses, when intended to punish her for exercising her free speech rights. The idea is that even small pressure to force an employee to compromise their political autonomy is a violation of the First Amendment. And Rutan says you cannot do this. Janus says you cannot do this. And I believe that this court said you cannot do this. This is just a different context. Instead of telling my clients that they're going to be fired or suspended if they don't support the union's collective bargaining activities, the union is going much larger and saying, if you don't actually become a member, you cannot have a voice and a vote in your workplace conditions. And I believe that that violates the First Amendment. Now, let me address...
A voice
Yeah.
and a vote, but they don't have to work there.
Well, that would be the case of any constitutional claim made by a public employee. That's the old case. You have a constitutional right to free speech, but you don't have a constitutional right to be a police officer. That was the early case in Boston, dealing with the Boston Police Officers Union. And, of course, that's not cited in any of the briefs. But that's the idea, and that is not an appropriate constitutional standard.
So
the standard today is unconstitutional conditions.
I mean, I may choose not to want to pay the dues for the Lions Club, but I don't necessarily have an entitlement then to vote on the Lions Club leadership. Where does it, and we wouldn't tell the Lions Club that they must allow me to do so, because by not doing so, they are coercing me to join. So where do we treat unions different from the Lions Club?
Your Honor, I think there's a clear line here. The Lions Club is not officially designated by the Commonwealth as the exclusive bargaining representative. The Lions Club did not, prior to Janus, have the right to be supported by every citizen in the state. The union exercises the authority of the state as the exclusive bargaining representative. It is funded mandatorily up until Janus. And so there's a significant difference between
So you're saying then that that what you're asking us to do is to considerably expand the scope of the duty of fair representation?
No, I'm not asking you to expand the scope of fair representation. I'm saying if you have a simple standard that says you cannot discriminate against an employee based on their union status, then my clients would have a voice and a vote in their workplace conditions.
Then you've lost me, because
Well-
I don't understand how you are saying that you're not asking us to expand the duty of fair representation when you're saying that that duty should include an obligation not merely to allow people to be heard, but to attend union strategy meetings and to be able to vote.
Well, Your Honor, there's no case that says the union has a constitutional right to exclude them. This union is excluding them. So if saying that I'm challenging what this union is doing would be an expansion, then that's correct. But I'm saying that my argument is a natural flows naturally from Section 5, which prohibits discrimination on the basis of union membership, and flows naturally from Leahy's point that duty of representation is a constitutionally guaranteed right. If it's constitutionally guaranteed, then Rutan applies directly here to say you cannot pressure these public employees to support the union's politics. Now,
You're
if I-
going kind of fast. Could you do that again, please?
I'm sorry?
You're going kind of fast. Could you just explain that again?
I'm sorry. I apologize. I saw the yellow light.
I'm kind of slow.
I'm sure that's not true. Your Honor, I'm saying that if you're asking me about expanding the rights of non-members, I do not believe I'm asking for them to be expanded beyond what either Section 5 says or what Leahy says, in that these are constitutional rights of clients, and Rutan then says you cannot pressure public employees to support union politics. If you're saying, am I attempting to expand this beyond what the union is doing right now, well, then the answer is absolutely I am. So,
Let me rephrase. Has any court interpreted the duty of fair representation as broadly as you're asking us to interpret it?
Your Honor, I know of no court that has specifically ruled on this issue. That is correct. I would say that Rutan is the closest case, and it just is in a different context.
Isn't Knight the closest case? Knight's almost on point. The U.S. Supreme Court says in Knight that an employer doesn't have to listen. You don't have a right, you don't have a constitutional right to make your case to an employer, right? And secondly, that you do have, unions can get a right of exclusive representation because it makes the collective bargaining process work. Knight seems to be almost right on point, isn't it?
Your Honor, if I might persuade you, Knight is not on point at all. And the reason it's not on point is this. Knight specifically disclaimed on this, this requirement that non-members pay for union politics.
But hold it, there's Knight is do the parallel with Knight. Knight involves, again, it's faculty, right?
Correct?
They want to have a say in these meet and confer sessions, right?
That's correct.
The union has the exclusive right to do those meet and confer sessions, right?
That's correct.
And the U.S. Supreme Court says there's no problem with that.
The U.S. Supreme Court says there's no problem if you are not compelling them to support union politics against their will. Let me give you the exact page citation for that.
But say that again, that
The-
they're not, the U.S. Supreme Court says you have no constitutional right to force the employer to listen to this stuff, right? The employer doesn't have to do this. It has a statutory obligation to negotiate with the exclusive representative, right? I just don't see how you get around Knight.
Well,
Go ahead.
Knight is this reflexive principle. The government doesn't have to listen to anyone, right? They can decide.
Well, you
who
get
they're going to
voted out
listen
if
to.
you don't, you get voted out if you don't listen. So government listens.
Right. So, but in this case, the general court has said that the employer will listen to the exclusive bargaining representative, and the exclusive bargaining representative in this case is saying, we'll listen to you if you pay for the political and ideological expenses. Knight specifically disclaimed passing on that. If you look at page 291 of Knight, note 13, it says, quote, this requirement to pay union fees is not at issue in this case.
Right, but it's not at issue in our case because Janus has already decided it.
Oh, it is at issue in our case, Your
No,
Honor.
you've won it already. They can't charge you for it.
But they are telling my clients that if they want to have a voice and a vote, then they must support them. And so this is not the coercion under Janus that you get fired or they automatically take it out. This is the coercion that they say you're denied a voice and a vote. I'm over. I'll answer any other questions.
Understand that you're not relying on Knight and you're distinguishing Knight, but is there anything, does Janus in any way modify Knight?
Well, Janus makes very clear that in Knight there is a constitutional considerations in exclusive representation. I mean, Janus did not mention Knight. Janus did not say we're overruling Knight. Janice said that with regard to exclusive representation, there are substantial problems with it. In fact, it means to me that Knight may well be on the ropes.
Well, you say that, but I mean, I'm going to read from Janus.
Sure.
Page 2465. The Abood Court, being, of course, the Supreme Court decision that was overturned by Janus, the Abood Court assumed that designation of a union as the exclusive representative of all the employees in the unit and the exaction of agency fees are inextricably linked, but that is simply not true. So they quite distinguish. They basically are saying what we are saying does not in any way affect the legitimacy of the exclusive representation of employees.
Well, Your Honor, if I might clarify, what I believe the court was saying was something a little bit different. The justification for the compulsory fee was the exclusive representation in part, and the free rider question in part. That goes back to the question that was asked of me earlier. Well, they don't have to pay, but they want to participate. It's the union status as the exclusive representative that triggers this right, not the issue of whether or not my clients pay. As you pointed out in Leahy, what happened when exclusive representation came in place, it took away the rights of the individuals to represent themselves, and it replaced it with the right of the union to speak for them. So our argument is, and I believe it is absolutely consistent with Janice, our argument is that you cannot leverage your authority as the exclusive bargaining representative to force my clients to pay for political and ideological activities, activities that were never chargeable, even in 1982 under School Committee of Greenfield, or in 1977 under the Abood case.
All right, thank you.
Thank you.
We'll hear from Mr. Casey.
Good morning, Your Honors, and may it please the Court. Tim Casey, Assistant Attorney General on behalf of the Commonwealth Employment Relations Board. With me at council table is Jane Gabriel, Chief Counsel for the Department of Labor Relations, who is with me on the brief. And with the Court's permission, I'll be arguing for 10 minutes on behalf of the Board, and Mr. Burrett will be arguing for 5 minutes on behalf of the unions. Your Honors, what remains of this case is a challenge to exclusive representation, which this Court has described as a basic building block of labor law policy in Massachusetts. Every court to have considered the constitutionality of exclusive representation, including the U.S. Supreme Court in Knight, has ruled that it does not violate the speech or associational rights of non-union employees. The employees in this case are asking you to become the first court in the nation to rule otherwise, based on a novel theory, that the union's internal rules, not dictated by the state, regarding who may participate in internal union decisions regarding leadership, policy, and negotiating strategy, violate the speech and associational rights of non-union members. But those internal rules are not state action, and thus may not form the basis for a First or 14th Amendment violation.
Isn't it, it gets tricky, though, because the union is the exclusive representative, which is a state-mandated process. So I'm not sure this, and we've separated, we've diluted state action, at least under the state constitution some. So I'm not, is it really fair to say there's no state action here?
Your Honor, I think under the U.S. Supreme Court cases, and in Janus, in a footnote 24, the court noted that it has become less willing over time to find state action when private actors are involved.
Yeah, but you've got, okay, but go ahead.
And one of the cases that's cited in that footnote in Janus was American Manufacturers Mutual Insurance Company against Sullivan, a 1999 decision where the Supreme Court reiterated that when it comes to ostensibly private actors, it has two requirements for finding state action. It requires both an alleged constitutional deprivation caused by the exercise of some right or privilege created by the state. We would probably concede that that aspect of the test is satisfied here. The unions are acting under their state law privilege of exclusive representation. But the second requirement is that the party charged with the deprivation must be a person who may fairly be said to be a state actor. Can the action be attributed in law to the state? So the question is whether union rules not dictated by or prohibited by the state. State law says nothing about whether and how unions may allow or forbid participation by non-union members In fact, the state typically treats internal union decisions as beyond the power of the board and the department to regulate. Whether that can be attributed in law to the state and thus constitute state action. In that same Supreme Court case, the court went on to say, action taken by private entities with the mere approval or acquiescence of the state is not state action. Here, at best for the employees, there is silence by the state as to whether or not non-members may participate in internal union decisions. Previously, Section 12 of Chapter 150E said that unions must allow non-members to vote on the ratification of a collective bargaining agreement if it contains an agency fee
Have
provision.
any federal courts interpreted this aspect of exclusive representation, state action aspect of that? Just,
Well, Your Honor,
'cause I don't think the U.S. Supreme Court's sort of talked about this in a state action context, has it?
Your Honor, there are lower federal court decisions that have said that the mere fact of exclusive representation does not create state action for everything that a union does. The Hallinan decision out of the Seventh Circuit, which we cite in our brief, for example. The U.S. Supreme Court did say in the Sedlowski decision that internal decisions about how unions conduct campaigns are not state action. In a later I'm sorry, Your Honor. In a later decision, the Beck decision, the court did reserve judgment on whether a CBA containing an agency fee provision.
I just find this part of this seems a little troubling because the state is only going to negotiate with the union. In fact, it will violate its bargaining obligation if it negotiates with anyone else. And the union is then expressly excluding the minority, the professors from any role there. I just find it's difficult to use the state action exclusively for you to win, but go ahead.
Well, Your Honor, as you know, we don't think there's state action here. We don't think the state has in any way dictated or encouraged.
If you lose that, do you lose this case?
Absolutely not, Your Honor. We believe that even if this court were to find state action, there simply is no speech or associational right violation here.
If I can, is it state action or unfair state action for there to be a duty of fair representation?
No, Your Honor. It is the other side of the coin of the privilege of exclusive representation.
Okay, so the state may obligate the union to at least exercise that duty of fair representation.
That's right.
Okay, so that's whatever you say about that state action, the state is entitled to do that.
Yes.
So what do you understand to be the scope of the duty of fair representation?
Your Honor, the duty is that unions must take into account the interests of non-members and must treat them equally in these respects. They may not negotiate more favorable contract terms for union members vis-a-vis non-members, and they may not act in severe bad faith in failing to represent or in the representation of non-union employees during grievance proceedings under the collective bargaining agreement. That's from this court's decision in Graham, which is cited in our brief. So the duty of fair representation extends both to the negotiation of the labor contract and to the handling of grievances under the CBA. I'm aware of no case which says that a private organization like a union incentivizing membership by offering benefits and privileges to those who pay dues while not offering the same benefits to those who do not constitutes a violation of the duty of fair representation. In fact, it's worth noting that in Janus—
Your brother argues that there's some kind of constitutional right to fair representation. Is that your understanding of that?
Yes, Your Honor. The Supreme Court has said in, for example, the Steele case, and I believe Vaca against Stipes, that it has implied a duty of fair representation under the National Labor Relations Act because it—
I understand it's a statutory right. Is it a constitutional right? Because they're saying that you have a duty of fair representation, and then they're building in some kind of constitutional free speech rights into that. I'm just trying to understand do you see there's a constitutional component to the duty of fair representation?
I think that the Supreme Court has said that if it were not a statutory right, it would, and has recognized it as an implicit right under the National Labor Relations Act because of constitutional concerns that would arise if there were not such a duty. In Massachusetts, it's recognized by statute in Section 5.
Right.
But as Chief Justice Gantz suggested, there's a limit to the duty of fair representation. It's a duty to be fair and to consider the interests of non-members in negotiating the contract and in representing them in grievances. As an aside, non-union employees have the right under Section 5 not to be represented by the union in a grievance proceeding. They can proceed without the union. They have a right to speak directly to the government in that respect, although the union has a right to be present, and the resolution of the grievance can't be inconsistent with the terms of a CBA.
Do you understand that duty to include an entitlement to be heard?
Your Honor, I'm sorry, I don't believe I understand your question.
If they say, this is what we would want you to negotiate, is there any entitlement that you hear that and consider that?
No, Your Honor. As Knight held, relying upon a 100-year-old precedent, the bimetallic investment company case, the government is under no obligation to listen to individuals when they speak to the government when it makes policy. That's, of course, to be distinguished from when the government adjudicates individual rights, where individuals have the right to notice and a chance to be heard. When it makes rules of general applicability, there's no constitutional right to be heard by the government. The employees have the right to speak, but they have no constitutional right to be heard. And so, a fortiori, they have no right to be heard by the union, a private entity that admittedly enjoys privileges under state law.
So, but what is that residual constitutional right that you, because you, back to my question on, you say you had a duty of fair representation includes some kind of constitutional backstop, right? So if you have this duty of fair representation and it clearly includes negotiating the terms and conditions of employment, is there some constitutional, that's what I don't get. Where's that, what does that residual constitutional right give them? Because it said you couldn't be charged fees, right? Because that was going to impact on their constitutional rights. But
Right.
what is that residual constitutional thing you're talking about give them a right to in terms of negotiating collective bargaining agreements?
Well, Your Honor,
Because I think you're saying none, right?
what I'm saying is that the Supreme Court hasn't said precisely what that would mean, other than to say that if it didn't exist, we would imply a duty of fair representation. But that's been interpreted by the courts and by the NLRIA and by our Department of Labor Relations to mean that there can't be discrimination in the negotiation of the contract and in the processing of grievances. But it doesn't require.
There is, but I think you're saying that the duty of exclusive representation gives you the right to discriminate in the sense of participation in the negotiations themselves, right?
Well, Your Honor, I mean only in the actual negotiation of the terms. So,
Right.
So the union couldn't negotiate more favorable salaries or leave policies for union employees vis-a-vis non-union members. I don't believe the duty of fair representation includes a right to listen or a responsibility to listen
Right.
to the speech of the non-members.
You have no right to listen, but you're saying there is some constitutional right to fair representation. There's something out there. He's saying that he needs an ability to speak. He needs a voice in the negotiation process. And I'm just trying to understand, because under collective bargaining law, there's no right to participate. But I just can't understand that residual right of what it gives them because it seems like it gives them nothing except for the outcome, meaning they have to have the same outcome of negotiations, meaning you can't discriminate between members and non-members in terms of what you get. You can't give the members pensions and the non-members 401ks, right?
That's right. And I believe that's all it means, Your Honor. I don't believe it means more than that.
So all it is the outcome has to be equal.
Right. So I think about it in terms of separating their right to speak and their right to associate. With respect to their right to speak, as I mentioned, they have a right to speak. They have a right to speak to the government in public. They have a right to petition. They have a right to write letters to their legislators. They can even communicate to their employers. What they do not have, what none of us has, is a constitutional right to be heard by the government, for our speech to be efficacious in any particular way when we speak to the government when it makes policy. With respect to their right to associate, they have a recognized right to associate or not associate with the union. Chapter 150E protects that right. But as Justice Seifer pointed out in her earlier questions, there is no constitutional right to all of the benefits and privileges of membership in a private organization without any of the responsibilities or burdens of membership here, including the requirement of paying union dues. And that is essentially the associational right that they're asking this court to recognize, which no court, as far as I'm aware, has ever recognized.
I think they're asking you to recognize a combination of what the chief was asking you, which is what is the duty of fair representation and what does that residual constitutional right give you in terms of the duty of fair representation? And what is your answer to that?
Your Honor, I would say that the Constitution requires no more than what the duty of representation, as it's been recognized in the common law and by statute here in Massachusetts, gives them.
So VACA has not in any way changed that? Because in the old days, VACA said you could charge people and it wouldn't be a constitutional right, that agency fee. The U.S. Supreme Court got rid of that, but they didn't in any other way change the duty of representation. Is that your understanding?
That's right. And in fact, Janice said explicitly in addressing this concern that states had that they would have to drastically alter their labor laws in response to the decision. The court said explicitly states can keep their labor laws exactly as they are. They need only eliminate the requirement of paying agency fees. Your Honors, I see that my time is up. If I could refer the court to one citation that is not in our brief, but that I would like the court to be aware of. It's a U.S. Supreme Court case, California Democratic Party against Jones, 530 U.S. 567, 2000 decision. This case holds that it would violate the associational rights of political parties for states to require political parties to allow non-members to vote in the selection of their primary nominees through a so-called blanket primary system. I cite that as kind of analogous support for the proposition that if the court were to rule that unions must allow non-members to have a voice and a vote in their internal affairs, that may well violate the associational rights of the unions.
Okay.
Thank you, Your Honors.
Mr. Burt?
May it please the court. Good morning. My name is Jeff Bird. I'm here on behalf of the union interveners. Your Honors, I'd like to begin by discussing the posture in which this case arose. The charging parties each filed a charge with the Department of Labor Relations asserting that agency fee, or challenging the union's demand for agency fees. The rationale in support of their charge or their charges was that it was included that it touched on the exclusive representation rights of the members, but at the end of the day, all of the charges were to challenge just that, just the agency fees, and that matter has now been definitively resolved by Janice, which, as we discussed in our brief, in our opinion, renders all the charges completely moot. They've also engaged in a subtle.
Let me stop you there, because in terms of understanding what you're asking for, you don't doubt that Janice governs our opinion here.
Not at all.
Janus governs. So you basically say we should declare it moot and not reach the merits. I assume you're not suggesting that Janus would not be governing law in Massachusetts.
If I understand the negative in the question, Your Honor, yes, Janus governs. It makes it unlawful in the state of Massachusetts and elsewhere to.
Okay. And you would have no objection if we were to declare it moot to declare that.
That's correct. That's
Okay.
correct. But nothing would be affected that hasn't been affected by the court's decision.
And you say that Janus in no way impacts or broadens duty of fair representation.
That's correct, Your Honor. But it raises an interesting question, and that is that this is not a duty of fair representation case. There's an assertion in the reply brief, and it is the first time that this assertion has been made throughout this proceeding, that this is, in effect, a challenge based on the duty of fair representation. Now, the charging parties and their able counsel had every opportunity to raise that in their charge as a challenge to the situation here involving the unions that I represent. They could have asserted that here, in the manner in which they're engaging with their members, and to the extent that they're given a voice and a vote, as the charging parties use that phrase, they could have raised that under Section 5, and they did not. So this is not a case that's assessed under the duty of fair representation.
So you're saying that this case has morphed from being a Janus case to being a duty of fair representation case, but that the agency appeal that we're reviewing didn't even address that issue?
That's correct, Your Honor. They didn't address the question of the relationship of what happens in the absence of agency fees on this kind of standalone exclusive representation argument that was made for the first time in the charging party's brief to the appellate court over the summer after Janus issued. It was never presented to the board in the first instance. Now, of course, this feeds into our other argument,
But
which is...
isn't the agency fee challenge was based on again, it's this kind of, I don't know, shadowy constitutional right we're talking about, right? Janus was a constitutional case. It wasn't a duty of fair representation case or even an NLRA case. It was what are your constitutional rights, and is the union violating its constitutional rights in terms of its representation or requiring you to pay, or right? Isn't that what that was?
Well, as long as we are separating the duty of fair representation case from the constitutional challenge, yes, that's what it was. Now here...
But isn't he saying that that same constitutional right, I'm not saying it's clear or it's correct, I'm just saying, isn't his argument that that same constitutional right that makes the agency improper kicks in here in terms of how you negotiate the collective bargaining terms and conditions, the mandatory terms and conditions of employment, right?
Well, I believe that is what they're arguing. My first response would be, however, that this was not the proper posture in which to bring that argument. That was, they acknowledged when they went into the doors of the Department of Labor Relations that the department had no authority to address that issue. It would have been for the judiciary in the first instance through an action-seeking declaratory relief to present that type of argument, and by improperly utilizing the department's procedures in order to obtain judicial relief, that is not the design of the system. And so
They had a statutory right to go directly to the appeals court once they were aggrieved, correct?
For review of the board's decision, and the board's decision was a finding that agency fees at the time did not constitute a prohibited practice, which is the determination that the department is specifically charged by statute.
So what they should have done to be procedurally correct before us would be to, as you mentioned, to seek a declaratory judgment in the Superior Court on this issue.
Yes, and that would have clarified the issues and sharpened the issues for this court's review.
And then
instead, they kind of
there would have
shoehorned.
been a full record before us to decide this important constitutional issue.
That's correct. I have many points I would like to make. If I could make one additional point in response to something that Justice Kafker said earlier, and that is that if politicians aren't listened to, they're voted out of office. Well, of course, the same is true with respect to a union, and the non-members do enjoy a right to vote on their exclusive representative, to speak with their exclusive representative, and to speak with their employers on their views on collective bargaining. So this, whether we're talking about a degree of voice and vote, that type of degree is something that could have gone to the department in the first instance, and it didn't.
Can I ask something I should know? Do non-members get to vote on decertification?
Yes, they do.
So they would have the same rights as a member when the 3-year term expires?
Yes, Your Honor. They do enjoy the statutory right. They can vote to try to change their representative. They can engage in campaigns in order to pick a representative they feel is more in line with their prerogatives. What they don't have the right to do, of course, is to force their way into the union's internal affairs, and in doing so, violate the union's standalone First Amendment rights to define its organization and of the original members who choose to support the union. And by forcing others to come into the table, it is destructive of both of those rights. There are as I said, other avenues that they can use to express their views on bargaining. And if they express their views to the employer, there are limits. Of course, the employer can't bargain with them, but they can hear them. They may choose to ignore it, or that it may have a shift in their position at the bargaining table. But what it does not provide, again, is the right to sit in on those strategy sessions and the decision-making processes of the union as they engage in their core activities of deciding how to run their organization. That's separate from their representational responsibilities, but it's that internal processes that is protected. And as a result, I will close by just saying we would state that the case is not properly before the court at this point, both for the reasons that I've outlined, but in addition, and primarily for the reasons that my able colleague, Mr. Casey, went through, this would be a first-in-the-nation type decision on rolling back the rights of exclusive representation, which is the underpinning of both national labor policy as well as the labor policy of the Commonwealth.
All right, thank you.
Thank you for the opportunity to present.